Okay, we're going to continue on with the reminder that we do have two time certain witnesses today. And I know Commissioner Williams had a movie quote the other day, and right now, from Top Gun, I have the need for speed. And so, take it away. I don't have a red ejection button, so that doesn't work.
We probably both benefit from that, Mr. Chairman.
It would really be a lot of fun.
Yeah. For one of us. Mr. Addison, I appreciate your being so forthcoming with me, and I do want to talk to you just to sort of get back to the 2015 order. You obtained through a settlement an additional $698 million in capital costs. Fair enough?
Yes.
And also in that agreement, I think the schedules moved from, and correct me if I'm wrong, but moved from 2017 on the second Unit 2 and 2018 on Unit 3 to 2019 and 2020. Is that your recollection?
Order?
20. It moved in the 2015 order.
2015 order?
Yeah.
Yes, it moved to June of 19 and June of 20.
Yes, sir. And there were some concerns about this time over the consortium's inability to provide you a schedule, wasn't there?
Yes, I believe so.
And do you recall that at least during the period March 2014 through May 2014, the fact that the consortium was unable to give y'all, the SCE&G and Santee Cooper, a schedule? Do you recall that?
I don't. That may be better addressed with Mr. Young. He's got knowledge of the construction.
Well, I would like to show you, if I may, hearing exhibit 34. It's a late filed exhibit. It was submitted, I think at the request of maybe Commissioner Irvin, but one of the, maybe it was Commissioner Hamilton. There are a series of letters from the Office of Regulatory Staff to Ms. Boyd. Do you see the first letter on top of this exhibit is March 20, 2014?
I do.
To Jocelyn Boyd, Esquire?
Correct.
And I'd like to ask, it reads, during the allowable ex parte communication briefing on February 26, 2014 of the South Carolina Office of Regulatory Staff informed the Public Service Commission of South Carolina that South Carolina Electric and Gas Company will be receiving from Westinghouse, the consortium, a revised integrated project schedule in the 2014 third quarter. Do you see that?
I do.
All right. And you would not have reason to disagree with the ORS statement in that regard, would you?
I don't.
Madam Court Reporter, thank you. And there was some, and I think there's been some testimony about, your in-house team, Mr. Brown, and his analysis of any realistic construction schedule for the project in that general time frame, wasn't there?
There was discussion yesterday about this team's work. I would not agree with the characterization as realistic construction schedule.
How would you characterize it? Because I didn't mean to. I was trying to accurately state it. I wasn't trying to.
Same as I did yesterday. That it was a calculation, as I understand it. I wasn't presented the information, but as I understand it, calculated based on the historical performance factors as opposed to what the consortium was presenting.
And there was a difference between the schedule that your staff suggested and the schedule that the consortium was presenting, correct?
objection asked and answered about 5 times, or maybe 10 yesterday in response to questions from Mr. Richardson.
Sustained.
And so you were aware that you're in-house you had some difficulties confirming the consortium schedule, weren't you?
I wasn't aware. I'm aware of what we discussed yesterday, but I wasn't aware at the time of the of difficulty confirming the consortium schedule.
Let me show you an email. It's an email chain as I describe it.
Put it on the Elmo so everybody can see it.
Well, I will. I have trouble reading the thing from over here. I was going to let him hold it in his hand, but I'm happy to accommodate. Let me show you. I'm just going to start at the top. Do you see? Can you see that, Mr. Addison?
I can.
Okay. At the top, it's an email from a Ronald Lindsay to a John Curry. Do you see that?
I do.
And then immediately beneath it, there was an email from Kevin B. Marsh, sent Tuesday, September 9, 2014 at 7:15 a.m. to Addison Jimmy E., Burns Stephen A., Lindsay Ronald. Do you see that?
I do.
And the subject was Summer Units 2 and 3. Do you see the subject line?
I do.
And Mr. Marsh informs you, among others, that it looks like Lonnie plans to disclose preliminary number from consortium. Has Carlette completed estimated amount with escalation? Do you see that?
I do.
Okay. And that would be Carlette Walker, would it not?
I believe so.
All right. And so then below that, you see the email from Carter Lonnie, sent Monday, September 8, 2014 at 6:12 p.m. to Marsh Kevin B., subject Summer Units 2 and 3. Do you see that?
I do.
All right. Now, I want to focus on paragraph number 2. Now, let me tell you, this is a 3-page document, and Mr. Addison, you're welcome to read every word. There may be something in here that you see that I don't, but with respect to number 2, do you agree with me that the document reads, with respect to negotiating a new project schedule with the consortium, my sense is that neither the owners nor the consortium have any real confidence that the proposed rollout schedule that the consortium shared with the owners on August 1st is achievable. You see that language?
I do.
And just to be clear, SCE&G and Santee Cooper would be the owners, correct?
Yes.
And Westinghouse and others would be the consortium.
Correct.
Does it continue to read, I am concerned that we have become tied to artificial dates, both past and future, often driven by disclosure considerations. Do you see that language?
I do.
It goes on to read, the owners and the consortium need a schedule that we will all have confidence can be achieved and thereby hold the consortium accountable to achieving milestones. Since the consortium is so far behind schedule, they should already take steps to mitigate any further delays. Do you see that language?
I do.
Mr. Chairman, I'd move this in as the next hearing exhibit.
This will be entered as hearing exhibit number 70.
Would you like to mark it, Madam Court Reporter? I might want it back.
All right. How if we mark it?
Well, I mean, just momentarily.
Oh,
I won't leave the room.
Mr.
Now-
Elliott, do you have copies for the council?
I don't. I just obtained this today. Would you like to? Let me show you a copy. You might be familiar with it because you've been in all these depositions and I have not. And I didn't mean to. And you take it. It's 3 pages. And let me. You're very gracious, but let me take that. I'm sorry, I didn't. Now, the date on this email chain, just to refresh you, is September 2014. Do you recall that? Can you see that?
I see that.
All right. And referring back to Hearing Exhibit 34, you'll recall that in March of 2014, the ORS was notifying the Commission that that y'all weren't going to have an integrated construction schedule until the third or fourth quarter of 2014. Do you recall that?
I do.
And so it would be consistent with the ORS correspondence in Exhibit 34 that the consortium had by September provided you with some idea about what their fully integrated schedule would be, correct?
Well, I think that time frame's consistent. I don't know if that is the product of that memo or not.
You answered my question. The time frame is consistent.
Right.
And to some degree, it is true, is it not, Mr. Addison, that Mr. Marsh would bring you in on some of this correspondence to keep you up to date. Isn't that a fair statement?
Occasionally, yes.
Yeah. And we can agree, can we not, that any delays that were not anticipated in the previous baseload review order in construction leads to additional construction costs, can't we?
Yes, I don't know that we know whose responsibility they are, but generally I would agree with that.
Right, delay, cost increase.
And unless it was a delay and work could not be done at all for a period of time and it's just being done later. Make sense?
Yes, sir. And so as a consequence of the fact that you didn't have a schedule for at least half of 2014, and notwithstanding the fact that your staff suggested that the $698 million was unrealistic, the delay still forced y'all to come in for an additional $698 million in additional capital costs in 2015, correct?
I want to make sure we did come back in. Yes, I want to make sure on the first part of your presumption there, though, that we did not have a schedule. I don't believe that's accurate, but Mr. Young can testify about schedules.
Good. He'll get a chance. And then as a consequence of the 2016 docket, order number 2016-794, the completion date approved by the Commission in that order was August 31, 2019 for Unit 2 and August 31, 2020 for Unit 3. Is that correct?
Yes.
All right. And then that order was issued in November, as I recall, November 28 of 2016. And within about 30 days, it became apparent that Westinghouse was in financial difficulty. Is that fair to say?
Yes, they made an announcement late December.
And
2016.
And there was concern at that time about whether or not Toshiba would be able to backstop Westinghouse. Isn't that fair to say?
Yes, I think that's fair to say at some point later. I don't know that it was immediate at that point in late December.
All right, sir. And I think you testified that you took some comfort in the fact that Toshiba had $12 billion on its balance sheet at the time?
Not on their balance sheet, market capitalization. So
market capital.
Yes.
And we subsequently learned in August that the exposure for the failure to build these plants was somewhere in the $4.7 billion range. Is that what you told the Commission on August 1st, 2017?
I don't recall a specific number.
Mr. Addison, they're still having a hard time over live stream hearing you, so I just want to make sure when you turn your head, you get that, get right in front of it real close.
Yes, sir.
Thank you.
I'll be glad to accept that subject to check for efficiency's sake.
Well, don't, because my number was a little low. Do you recall appearing at the ex parte, I'm sorry, Mr. Addison, at the ex parte briefing on August 1, 2017 with Mr. Marsh and Mr. Byrne?
Yes.
All right, and do you recall that, can you read that from here? I can show you what I've got.
I can read it.
Okay. You recall presenting one slide to that ex parte briefing that says Unit 2 and Unit 3 abandonment cost, current estimate $4.9 billion. Do you recall that number now?
Yes.
All right. And so Toshiba had $12 billion on market capitalization, $12 billion market capitalization. Now, you know generally from press reports that Vogel was building 2 plants at the same time, correct?
Correct.
And you know generally that Vogel, the Toshiba's exposure to Vogel would be worth approximately the same $5 billion figure. You know that from at least press reports, don't you?
Yeah, I won't argue with you on that. I think there are different contracts in the different states, but there was exposure to both projects.
And if they were both equal, as I suggest, then Toshiba's exposure from the two of you would approach $10 billion, correct? If I'm correct that Vogel's exposure is the same, and I'd urge you to double check as the exposure to SC and G, then they're looking at a $10 billion problem, aren't they?
I'm not sure I follow your question. So are you focused on the parental guarantee that they're responsible for?
In a moment. Just the exposure generally is Westinghouse's exposure is $4.9 billion, according to you and Mr. Marsh and Mr. Byrne on August 1 of 2017.
I think we're crossed up here. The $4.9 billion was the cost incurred to date, not the projected cost to complete.
Right. And so in theory, and you can ask all your 19 lawyers, but in theory, Westinghouse's failure to build the plants could lead to a $4.9 billion lawsuit by SC&G against Westinghouse, couldn't it?
I understand your question now.
Okay. Yes. So if there's similar exposure at Vogel, my point is that somewhere in the neighborhood of $10 billion exposure would be the case, correct?
Well, that presents SC&G's share, not the total project for summer. Santee's portion would be in addition.
It's worse than I suspect. So the exposure between Vogel, SC&G, and Santee Cooper could exceed the $12 billion market cap of Toshiba, correct?
Yes, it could.
All right. That's all I'm asking. You're welcome to explain anything further, but that was my point. Now, subsequently, Westinghouse declared bankruptcy, correct?
Yes.
And E&G determined, and Santee Cooper determined that it would explore the possibility of building these plants on its own, correct? Yes. On their own, correct?
Yes.
And so y'all did some extensive due diligence and concluded that ultimately concluded that the plants would cost an additional $2.2 billion to that which you had originally thought and had informed this commission?
I don't have that specifically. If you...
I'm happy to help.
If it's somewhere, that would be great.
I do indeed. Mr. Chairman, I am showing the witness a copy of the August 1, 2017 transcript of the August 1, 2017 ex parte briefing by SCE&G. It is on your website. I would ask that the Commission take judicial notice of that because I think it would be helpful to you in your examination of these issues. And
yes.
We will.
Thank you. And let me just show you, Mr. Addison. This is the front page of the transcript, and just take a look at it. It'll tell you that it's before the Public Service Commission and the date.
I agree.
And you recall being present.
Yes, I do.
And you're there with counsel. I mean,
Yes.
you have.
Yes, sure.
And I point to you to page 15 of the transcript at lines 1 through 4 and ask you if it does not read, the resulting estimated cost to complete both units is approximately $2.2 billion more than the comparable costs as approved by order number 2016-794.
That's correct.
All right. And I will tell you, just in fairness, that's Mr. Marsh's testimony.
Thank you.
And put this, this is a page, just so that you're comfortable. This is a page out of Mr. Jones's testimony. You recall his testimony.
Yes.
And you would agree with me that you informed the Commission on August 1, 2017, that after you made your investigation, SCE&G and Santee Cooper made their investigation of the matter, the earliest conceivable completion dates would be, your eyes are better than mine, December 31, 22 for Unit 2 and March 31, 2024 for Unit 3, correct?
Correct.
All right. And those dates are beyond the dates. Those dates are beyond the dates in the 2016 order of August 31, 2019 and August 31, 2020, aren't they?
Yes.
I'm through. Thank you, Mr. Chairman.
You're finished?
Absolutely.
I didn't even have a response. Thank you, Mr. Elliott.
Would it help, Mr. Chairman, if I go a little longer, give you some time to think?
No,
Yeah.
thank you.
Good.
I've got a good story. No. Mr. Tyson.
Give me 1 minute, Mr. Tyson.
Good morning, Mr. Chairman and fellow commissioners. Mr. Addison, I am going to, you'll like me better than my table mates when it comes to length of question, just so you know on the front end.
Thank you.
Mr. Chairman and commissioners, I'm Rob Tyson here on behalf of Speaker Jay Lucas. Mr. Addison, in all seriousness, I do just have a handful of questions. Were you here for the opening remarks?
Yes.
And you heard Mr. Anselmo, and you talk about Speaker Lucas's desire for certainty, right?
Yes.
Okay. And how we need a plan moving forward, correct?
Yes, I did.
Okay. And would you agree with that?
Absolutely.
And you understand that the Speaker believes the experimental rate that was approved by the General Assembly earlier this year provides certainty, right?
Right.
Okay. Would you agree with that?
Yes.
You would agree with me, though, I think, or would you agree with me that SC&G challenged the experimental rate, correct?
We did.
And you sued this commission in federal court, correct?
That's correct.
And you understand Judge Childs made a ruling, right?
Correct.
And she ruled that the experimental rate was fine, and she authorized the commission to approve that rate, correct?
Yes, I think that's the end of it. I'm not an attorney, so I can't analyze everything that came out in her order, but that's the effect. Very well aware of that.
The experimental rate's in effect today, correct?
Yes, sir.
Okay. And it ends in December.
Yes, sir.
Until whatever the final rate is that the commission sets, correct?
Right.
And do you recall your testimony yesterday when you said that the new law changed, I should say, the definition of prudency?
Yes, sir.
Okay. And did you know that in this company's lawsuit against the commission, that you brought that allegation up also?
Yes.
I'm not as probably going to be as skillful as the folks here, but if you'll give me a second. This is the order of that lawsuit, and you can see. Let me just start.
Just make sure you stay in front of that mic before you talk again.
Mr. Chairman.
Yes, sir.
Mr. Addison, you see up there at the top, it's the federal court, correct, and the U.S. District Court.
Yes.
And you see the date up there on the top. It's August the 7th. That's when the date was filed, right?
Yes.
And you see over on the right, or let's go to the left, you see SC&G is the plaintiff, correct?
Correct.
And then you see all of the defendants there. Right below that are all individual commissioners, correct?
Correct.
Okay, then you see over there that the what it says, it's an order and opinion denying SC&G's motion, correct?
Yes.
Okay.
I'd like to note that my name is spelled incorrectly on that.
Your Honor, I'd like to note that the plaintiff brought the case, and so they were the ones that misspelled your name.
Touché.
That would be mine as well.
Yeah. Commissioner, I'd like to also note that the plaintiff was the one who misspelled your name. Now, let me show you on the second page of this order, as it goes in.
While you're looking, I'd like to note that I wasn't even sued. I was left out of the caption.
I think you can also take credit for the plaintiff not doing it.
And I'll note we are not going to amend to add you.
All right, Mr. Addison, if you look in that paragraph that I've shown you right there, it kind of highlights a little bit of what the background is. And you see right there in the middle of it where it says that the defendants in their official capacities as the commissioners will implement, and then it has open parens, the act of June 28, 2018. And then at the end of that, it refers, the reference in the parentheses is Act 287. You see that?
Yes.
Okay, and so that's the act that was passed by the General Assembly earlier this year, correct?
Correct.
Okay. And so as we go through this order, okay. Is that better? Mr. Erskine, how would can I bump that up a little bit? Can I zoom that where that footnote stays in there? Because that's all I want to show is just that. Go the other way. Oh, Mr. Chairman, let me do this too. As you've seen, this was the order that was in the federal court case earlier this year. I've got copies here and would like to move that to be introduced as the next hearing.
Okay, we will enter it as hearing exhibit number 71.
Mr. Addison, can you read that, or do you need me to?
I can read it.
Copy. All right, so let's go back. So we've got the federal lawsuit. We've as you just testified, the experimental rate was approved by the federal court, and that's the rate that's currently in effect, right?
Yes.
Okay, and then yesterday you said the new law changed the definition of prudency, right?
That was my understanding.
Okay, and then in this lawsuit, that was part of this subject. And so in this order that we've seen, and it's now here, I just want to show you a few lines, please. Can you see, I've highlighted it, so it like I said, it's a footnote, but just so you can see. You want to start right there where it says, however, that's shaded, and read that sentence for us, please.
However, the BLRA did not define prudency, so the Act cannot redefine prudency.
So all right, then how about the next sentence?
Instead, the Act provides the first definition of the term prudency and imprudency as related to the BLRA.
And then you want to just, well, let's just go with that right there. So what is she saying there?
Well, as I read it, she's saying that it wasn't defined originally in the BLRA, so the new law could not change it.
And then the next sentence there says, altering statutory definitions, or more importantly, adding new definitions of terms previously undefined is a common way of amending statute, right?
That's right.
So Judge Childs did rule, and she rejected your argument, didn't she, that the Act changed the definition of prudency?
It appears so.
And she says, in fact, instead the Act provides the first definition of the term prudency, correct?
That's my understanding. Yes, sir.
Mr. Addison, I'd just say that I'm glad the federal court has found that the new law provides certainty for both the rate and the definition of prudency. Thank you. No further questions.
Thank you, sir. Okay, I think we're to commissioners. Commissioner Elam.
Thank you, Mr. Chairman. And I won't get on Mr. Balser about whether that's not naming Commissioner Irving would be a failure to join a necessary party, but that's lawyer jokes, and they're never as funny as you think they are.
That's true.
Oh, don't get me started on the mayor jokes either. Good morning, Mr. Addison.
Good morning.
Earlier in your testimony, you stated you were talking about your duties as CFO, and you said your job then was to raise capital. Is that right?
Yes.
And during the course of testimony, you have answered several questions, basically saying you weren't in the loop on a lot of the construction, the issues related to construction or the progress of the plant. Is that fair?
Well, I didn't have an oversight role for the construction. I certainly was in the loop, if you will, on a quarterly basis through the review of our BLRA quarterly report that we would file with the ORS and this commission, and the filing of any of our SEC documents.
Okay, and you were in the loop enough to know that perhaps substantial completion dates were slipping, and that perhaps the work product on the site wasn't what SC had hoped it would be.
Yes, sir. I think that was clearly laid out in our quarterly reports.
Okay, I wanted to understand that because I didn't know how you could raise capital for the project if you really were that unfamiliar with the project.
No, I didn't mean. It's just I didn't have a construction oversight role. I reviewed each of those quarterly reports and was up to speed with what we were reporting to you.
Okay. Talking about the Bechtel report, can you tell me when did you first become aware of the Bechtel report?
Well, as I said earlier, I was aware that they had been retained. Around the time they were retained, it was reported to our board.
What date was that generally?
I don't recall specifically. It was in the record yesterday. I don't remember exactly when that was.
Okay.
I believe it was in the record yesterday.
Right. We'll go from there. Did the company have an obligation to inform the commission and the ORS of the report's existence?
As my understanding, that the work was engaged by the owner's attorney under privilege, and so I don't know if there was further obligation or not to report the report itself. I believe it would have violated privilege had it been reported.
Okay. Was the genesis of wanting to get Bechtel on board or retain Bechtel, did that come from SC or Santee Cooper or where?
I don't know because I wasn't involved in it.
Do you believe the company had an obligation to inform the financial community of the existence of the Bechtel report?
Again, I think it's the same answer. I think it was retained by counsel. And what I will say is, if there was something that was not otherwise known that was material to the project, then I would agree with that. But I don't know whether there was. I'm not aware that there was anything, any issues identified that were material that were not otherwise known and previously disclosed. That's what I'm left to conclude.
When did you inform the financial community of the Bechtel report?
I believe the financial community became aware last summer when the report was discussed before the legislative committees.
What was the financial community's reaction to it?
Commissioner, I don't remember a specific reaction. The reaction was already, there was already a lot of concern by the time that came up based upon having to withdraw the application to this commission for the abandonment that we withdrew in August of 2017. So that was the predominant issue.
All right. And about the Bechtel report, I think the company has testified, and I believe it may have been in an opening statement, that ORS knew everything in the Bechtel report anyway, so they shouldn't be crying foul over not seeing the report itself. Is that a correct characterization?
I believe the characterization was that there were no new issues identified, and I can't speak for Witness Jones, but I think he said that there were no new issues identified. I think the exception he took was around schedule.
Well, if there are no new issues, and they in essence knew everything, why would it be confidential?
Again, as I understand it, it was retained by counsel for the purpose of either protecting the owners or pursuing litigation against the consortium, and if it were waived, I understand that has legal ramifications. I'm just not an expert in that.
What would be the ramifications over and above what was already publicly known?
I don't know the answer to that, but as I understand it, we're going to have a witness here that can address all of those issues next week, Mr. Winnick.
Mr. Winnick contracted for the report. The genesis of the request to ask for the report was not Mr. Winnick, correct?
That makes sense to me, but I was not involved in the decision, so I don't know.
One of the intervener witnesses has a statement in his testimony that SCEG or SCANA turned down a $2.2 billion offer for Public Service North Carolina. Do you recall seeing that?
Yes.
Is that correct?
That's disclosed in our merger proxy statement.
Okay. Did you have any other offers for any other affiliate companies?
No.
And that was only one offer for PSNC?
That was a very preliminary discussion. It wasn't a formal offer.
Can you tell us who made that offer?
I know the answer to that. I don't know if I should. I don't know the answer about whether I can or not.
Who made the offer?
Let me just make sure that I can answer that.
Commissioner Elam, I believe the answer to that question is subject to a confidentiality agreement with that other party. And I don't have that confidentiality agreement here. And I certainly would not want the company to breach that agreement. Can we check over lunch and then what the status of that is and then immediately report after lunch? Certainly would not in any way not want you to have the information if we're not violating any provisions of an agreement to provide that to you.
Okay.
And I'm not sure there is an agreement in that case, but I would prefer to be completely accurate about that.
Right. Do you see any drawbacks to the merger with Dominion?
Plus, I suppose the biggest drawback would be not a company that is solely based here in South Carolina anymore. Dominion is committed to keeping a headquarters here. There will undoubtedly be some headcount reduction in some of the administrative services. Dominion's witnesses can speak to this, but I believe that they will do everything they can to make sure most of those occur through attrition. But I think the benefits for the customers and for the stability of the company in the long run far outweigh any concerns.
I believe it was Mr. Collin or someone else said there were about 1,750 employees in Casey. Is that about right?
I think he said in the service company, and our service company is a virtual service company, so some of those reside in all 3 states.
Okay. And would employees in all those 3 states be subject to layoffs, service company layoffs?
I think theoretically they could. I think what he may not have been aware of is that about a third of those 1,700 are customer service related employees. And you can ask Mr. Farrell next week, but I believe he doesn't anticipate any significant changes there. So I think Mr. Cullen was more used to the typical situation where service company employees are accounting, IT, HR, et cetera. I think he used some of those examples. And a significant piece of our service company employees are customer service employees, call centers, et cetera.
How many employees in Casey are subject to layoff if the merger goes through?
I believe the Dominion would be better to respond to that based upon what I have heard them say, that I think there will be very few that lose their job if they don't want to retire or something of that nature. I think attrition can address a lot of that. And let me give you a point of reference. Compared to 12 months ago, we have 200 fewer employees across the company than we had, excluding new nuclear, aside from those 550 or 600 employees. We have been very tight with the purse strings, doing only what we had to do for 2 reasons. 1, to retain cash, and 2, to prevent hiring someone that might later be impacted personally in a situation like this. So we've tried to do our best to alleviate that situation.
So are you saying that you haven't been hiring new people since the merger announcement?
No, that is in addition to net of the new hires. So I don't know the number we've hired. It's well in excess of 100 during that time period for critical roles. But we have, it's a very robust economy. And in the uncertainty that we're under, employees, especially if they're fairly young in their career, they are making another choice to go somewhere else for the stability.
Maybe I shouldn't assume, but I assume the company conducts exit interviews with people that are leaving the company. Can you characterize a main reason why some of those 200 employees have left?
A lot of reasons. Some just retired normal retirement time. But I would say of those that left earlier in their career is the uncertainty.
Okay. Do you foresee any major impact on other businesses in the community that service the campus out there in Casey? What will not be required if the merger goes through?
I don't know of any examples of that. Mr. Farrell's been very clear with our employees and his team has across all 3 states that he expects the businesses to operate largely as they are today, less any efficiencies that are there because of systems changes or something of that nature. And let me just say, the majority of the integration, there's limited planning that can go on now because the merger is obviously not approved. But the majority of the integrations from a system standpoint, back office standpoint, would not happen until 2 years from now.
Okay, and I was going to ask about that. That's part of, any time mergers happen, integrating IT systems is probably the most difficult thing to do. Is that fair?
IT systems and ensuring the cultures blend.
Right. And that's part of the costs that Dominion has pledged not to pass through. Is that correct?
That's my understanding.
talk a little bit about the mechanics of refund or rate credit going forward. And maybe a Dominion witness is better for this, but the question I have is, and I don't know if I'm using the right word or not, churn. What's your general turnover rate of customers leaving the system in a year and new customers coming on the system?
Yeah, I don't know the answer to that, but certainly operating in a very robust, growing state, as well as a state that has large universities in Columbia and Charleston, that happens. We've got those customer records, and you're right, the Dominion witness needs to speak to this, but what I've heard Dominion say is they're open to the preferred solution of the commission and the ORS, certainly, their input.
So if you had to try to get a readout of who was a customer up to March 12th, 2015, who was a customer after, your systems would be able to generate a report like that?
Yes, sir. Now, how do you find them for forwarding and that kind of thing? You've always got that challenge, but
right.
Yes, sir.
Make sure. I think one more. Oh. It's been referenced that there are 15 state court actions, customer, maybe a class action suit. If you were to lose or settle those cases, who would pay? Stockholders? Customers?
I don't know the answer to that, but my reaction is that stockholders.
Is there a stockholder action also?
Yes.
Pending? Who would pay for that?
The company would.
Right. Okay. Would that mean passed on to ratepayers or no?
No.
Final question. Prior to signing a fixed price contract, did Westinghouse have an incentive to improve labor productivity?
I believe so. Again, I'm not the construction person, but certainly they were banking their strategy on the successful completion of these projects in the U.S., their international strategy. So I think that was very important to that long-term strategy.
Okay. I lied. I have one more. The company testified that if rates under Act 258 are made permanent, the company's financial status would be severely impacted. Is that correct?
Correct.
It appears, though, that the alternate plan rates and the Act 258 rates differ by about 1% on a residential customer's bill. Is that right?
That's correct.
Is there anything preventing the company and Dominion from accepting Act 258 rates under the merger?
I think only Dominion can respond to that, Commissioner. And what I would say is that the way we've it's been very difficult the last several months. Financially, it may not look that way. It may look very smooth on the surface, but there's a lot of paddling going on, and Ms. Griffin can give you more details around that. It's very difficult, for example, to place our commercial paper every day or almost every day. It's very, very difficult. Some days none of it's sold. We have to fall back to the banks. The way we have treaded water in the interim is an 80% reduction in the dividend rate. And I don't think that's sustainable in this industry in the long run to be able to attract the $500 million of capital we have to attract each year. And that's why we need a solution to this that's more robust than SC&G can provide.
I've always found that your linemen and other workers are very good at handling floods, and I always appreciate their work. I know what you're talking about.
Yeah, they're outstanding.
Yes. That's all I have, Mr. Chairman.
Thank you. Commissioner Hamilton.
Thank you, Mr. Chairman. Good day to you. Good morning.
Make sure you get close to that mic, Commissioner.
All right, we'll
Good morning.
Follow all the rules of the chair.
you.
Mr. Addison, could you please provide an update on the company's ability to operate its electric and gas systems after the abandonment?
Yes, sir. We've worked very hard to maintain our reliability, safety, and customer service standards. Our performance is, in most cases, in the top quartile of our industry as measured by our industry peer group. And we have made decisions around financial constraints in areas that we tried our best not to impact those areas. So we have sustained that for a period of time, and we're very proud of that. In fact, I'll knock on wood as I say this, I think we've had one of the safest years on our system this year for our employees, which is critical to me in a year when there's so much distraction. Our customer service has been outstanding. Fortunately, we've dodged a couple of bullets with these major storms, but we've responded to those, and I'm very proud of those employees.
How many employees did you have prior to an abandonment? Mr. Elam went into this a little bit, but
About 6,000 in total across all three companies, so I don't have it broken out by just SC&G, but the lion's share of those are SC&G, and about 550 or 600 of those were related to new nuclear, and most of those are no longer involved. And as I said earlier, we're a couple hundred down across the rest of the companies.
thank you, sir.
Yes, sir.
Tell me how you've been able and how successful you've been in operating the systems effectively under the experimental rate that we have in effect today.
It's not been a long period of time, but we, as was discussed with some of the other witnesses, we refinanced a great deal of debt, about $700 million, I believe, a few months ago at a much higher rate than we think we would have were we not under so much uncertainty. But that has provided the cash to sustain during this time period.
If this rate was a permanent rate, do you think the company would be able to withstand and operate in the future effectively?
As a standalone company?
Yes, sir.
I think it would be extremely difficult, and at best case, it would result in a much higher cost of capital because of the risk associated with it. I mean, as I said earlier, the way we've, if you will, treaded water the last several months is by an 80% cut in the dividend, and a dividend rate of that level will not attract capital at an efficient level in this industry on a long-term basis.
Do you think the merger would be more beneficial to the stockholders or to the ratepayers?
I think it's a balance of both, which is exactly the reason that I felt the presentation Mr. Farrell made to me almost a year ago deserved the attention of our board, because he brought a solution that was focused on the customer and not just a shareholder, which is typically the approach in a merger. And I'll tell you, if the merger closes based upon the current stock price of Dominion, the shareholders of SCANA will have absorbed several $1 billion, I think $3.5 to $4 billion in losses compared to a couple of years ago.
Thank you, Mr. Addison.
Yes, sir.
Thank you, Mr. Chairman.
Thank you, Commissioner. Commissioner Howard.
Good morning, Mr. Addison.
Good morning.
I've got several questions all over the board, so there's no consistency, so we'll just jump around.
Sure.
The first one was, how did you arrive at Timmerman's compensation of $360,000 a year? How would that figure arrive?
Commissioner, I just don't know the answer to that. I was not involved in that discussion at all between Mr. Marsh and the board and Mr. Timmerman.
Well, that brings me to another point. I find it extremely hard to believe that you're a CFO, and I've heard so many I don't knows out of you. I would think every time we had a presentation, well, that's not true. Most of the time we had a presentation, you were here with Mr. Marsh and Mr. Byrne. Three of you sat at a panel right there.
Yes, sir.
So therefore, I just assumed, bad mistake, that you knew everything going on with the project, particularly in view of the fact that it was just pointed out that you would have to go to the capital markets and explain what was going on with these projects, but yet you didn't know. I mean, how did the credit analysts determine that you didn't know, and how did they determine whether your offer was agreeable or the bonds interest rates were agreeable?
Yes, sir. I understand your question. So I relied, as I said earlier, I relied on our disclosure process for all of our employees throughout the company that produce information each quarter that goes in our disclosures. Excuse me. I relied on the BLRA quarterly reports that were critical, and that involved probably 15 to 20 employees that were on the construction team, the construction managers that would provide sections of that. So I reviewed that and was knowledgeable about it. I was in presentations when Mr. Byrne would update our board of directors quarterly, as well as sat there with him as we had quarterly analyst calls. So the real meat of the answer is that I did not provide that information about the construction schedule to the investors. They were getting it directly from those that were knowledgeable about the construction. And Mr. Burns sat there with me on each quarterly call.
Let's talk about the, what is it, EAC?
Yes, sir.
Were you a part of that group?
No, sir.
How could a company have a group estimating the cost of the project at completion without the CFO being part of that group, or at least knowledge about what's going on within that group? And the third part, I guess, I'll go ahead again. Why didn't you have confidence in those people? Why would you choose to select the opinion of the contractor over those of your own employees, experts, that really had a concern for the financial viability of the company? How was that decision made in your mind? Why did, it's hindsight. If I was in your position, I think I'd have sat in on those meetings, because that was a critical thing. And then what point, what was this decision making? What made you say, well, my group doesn't know what's going on, I'm going to go with this group? What did that group bring to the table that your group did not bring to the table?
Yes, sir. It isn't that there wasn't confidence in the employees. I think they made the calculations correctly. They were just, as I understand it, extrapolating, taking the historical performance factors and saying, if this doesn't improve, what's the total product of the cost here? As far as why I wasn't involved in it, all of our financial teams are decentralized around all three states and work directly with the businesses. I believe this was occurring in the fall of 2014. I had an assignment the last half of 2014 to sell two of our other subsidiaries, which we did, and used the proceeds of, I think, $450 million or so to invest back in SC&G's nuclear project. So I was running those two projects in parallel during that time frame. But we had CEO, COO, Vice President of Nuclear all assigned on the project. And I also took over in the middle of 2014 as the president of our Georgia business. So I had also responsibility for the Georgia business from that point forward after Mr. Bullwinkle retired.
Let me see where I'm going to get with this one. The Bechtel report. Who in your organization knew about the Bechtel report, both name and title?
Yes, sir. I don't have that list. I mean, I'm aware from the...
Give me a number then of how many.
I don't know the answer to that. I wasn't one of them. I don't know the answer to that. I understand that it was a limited group, but I don't know. Maybe Mr. Winnick can answer that question next week. I'm not sure.
You mentioned just in one statement, it might have been on an exhibit, the board website. You remember that? Did I misunderstand this?
Give me some context. Sorry.
I remember they went to the board website. I mean, does your board have a special website?
The board does have a board tool, a portal that they use to get board information.
And that portal, I assume, is not accessible by the general public.
That's correct.
Anyone except board members.
That's correct.
And another one of, I don't know, questions that sort of sitting back amazes me is that the company could allow an expenditure of $1 million and the CFO did not know about it. I mean, that just, who would make that decision and circumvent you? And the $1 million would be for the Bechdel report.
No, sir, I was aware of that. I was aware of the cost. I was aware they were retained. I just did not see the presentation or the product that they presented.
Okay. Thank you, Mr. Addison.
You're welcome.
Thank you. Commissioner Whitfield.
Thank you, Mr. Chairman. Good morning, Mr. Addison.
Good morning.
Mr. Addison, I'm going to kind of follow up where some of my fellow commissioners have gone, and I guess to try to keep from going all over the place, as Commissioner Howard said, I'm gonna try to stick to part of my questioning to do with the shock or blindsidedness this commission was hit with, and the other part, the most important part, public trust and the interests of the ratepayers. First of all, I'd like to say that I sitting here, I never knew Mr. Timmerman, never had him come before us since I've been on this commission, but I certainly believe you and Mr. Byrne, and I believe Mr. Marsh, and I believe Ms. Walker and Mr. Torres, and all the other witnesses that came before us. And in your opening statement, you talked about the lengthy hearing we had, and obviously a lot of other people believed in your testimony too, because you didn't say this in your opening summary, but now Mr. Elliott has brought it out. Supreme Court affirmed these decisions as well, right?
Yes, sir.
So obviously a lot of people believed in you. And I want to shift gears from the others, the names that I've mentioned, to you, since you're the one on the witness stand right now. It seems to me that there's a little bit of a lack of a better word, as Commissioner Howard was going down, for lack of a better word, a firewall almost between you and the other executives, Mr. Marsh and Mr. Byrne. And I've always understood your role to be, as CFO, that you were the one that went to Wall Street and you did raise that capital as you've testified. But is the characterization of a firewall fair, or it sounds like you were left out, or for whatever reason, as Commissioner Howard mentioned, maybe chose not to go to a meeting? It sounds like to me, and I understood the company to be a large company to us, while not large in the utility world nationally, a large company to us here in South Carolina, and fairly compartmentalized. But it sounds like you're way more compartmentalized than at least I ever understood. Could you maybe describe that?
Yes, sir. So I didn't feel walled off. I felt like that material information made it to me through the disclosure process, and we have a robust set of controls that are executed monthly and certainly quarterly are critical to all information getting to the appropriate disclosure, whether it's SEC disclosures or disclosures to the ORS and this commission through our BLRA quarterly reports. My responsibilities, although they changed over time, included several areas, included typical finance areas, treasury, tax, accounting, but they also included, for example, IT. Approximately 400 IT employees in the systems across all 3 states. So we are a fairly small company in this large business, large industry, and I feel like I paid attention to the responsibilities that I had, and my responsibility around the project was to raise the capital, and that's why you saw me in the evidentiary hearings back in 2008 and again in 2016. And I think the only times I was before this commission other than that was in some allowable ex partes around an accounting treatment we were looking for, or when the fixed price option came along, Mr. Marsh said, I'd like you to get involved in this in October of 15. I'd like you to get involved in the fixed price option hearing here in 2016. So I don't mean to imply that there was a wall at all. I feel like the appropriate information made it to me through the proper processes.
And you mentioned the 2016 fixed price option. I guess you obviously, goes without saying, you understand that this commission certainly believed in that proceeding that ratepayers would have to absorb no more costs going forward, and another rate case would not be sought until Unit 2 was supposedly in service and online.
Absolutely. That was part of our commitment in the settlement that we reached with several of the interveners.
Back to your role, as I'm talking about CFO, not CEO.
Yes, sir.
And I realize your function was to raise capital, and now you've attested to being over IT people and that sort of thing. And I think you acknowledged to Commissioner Howard just a minute ago that you were aware of the $1 million payments for the Bechtel reports, but the ORS witness had a ledger of numerous other payments to Bechtel for other things, and some of that goes back years before the report, the alleged Bechtel report. And if I remember right, the cumulative total of that ledger that was up on the screen the other day was a little over $6 million. Were you aware of any of these other expenditures as CFO and what they might have been for? Or had you seen Bechtel even in your ledger? Again, I realize you had a lot of duties, but...
No, sir, and I don't have I don't routinely review the accounting records of the company. I'm reviewing the product of it and looking at the overall results. So the accounting function that's out throughout the companies would do that. I was not aware that Bechtel had done other work for us until I heard that in the hearing room here a few days ago. I'm sure others on our staff, like Mr. Young, I'm sure he was aware of them, and he can verify that when he's up later.
Fair enough. The list that was put up on the screen as an exhibit the other day while you were on the stand of the executives that would receive payouts or stock, if you will, or other options. I know you mentioned 2 of them who are no longer with the company. The others of you were still employed, and I think you went on to say that you would not receive that unless you were terminated or separated from the company. Is that right?
Correct. 2 requirements. Merger has to close, and you'll lose your job.
Who were the other? There are only about 6, and 2 of them are gone. Who were the other individuals, if you could?
I believe, subject to check, it was, no, those are just the ones that required to be disclosed for the SEC document. I believe those were Mr. Kassam, Ms. Griffin, our CFO, and maybe Mr. Harris, who runs our gas businesses. I don't recall.
So Ms. Griffin, Mr. Kassam, and possibly Mr. Harris, and you, of course.
Yes.
And you. Let's. Where is Mr. Torres now? I think I've been told he's not there anymore.
I understand he is working internationally on construction projects.
And you might remember somewhere in the 2016 proceeding, Ms. Walker had always been in front of us, and of course as I said, we believed her too. So I even asked, I think in that proceeding where she was, I think I was told in the transcript that she was no longer with the company. I don't remember the exact wording, but does that sound correct too?
Yes, sir.
Prior to that, or it came out at least to me during that case.
Yes, sir.
So Mr. Torres has left the company. Let's talk about Actually, let's go to the most important part, and there is something I want to ask you after that. Let's talk about the ratepayers. In talking about the company's plan, and then talking about the latest alternative plan that's been presented. I talked about the public trust having to be restored and looking out for the public. What can we do, as Commissioner Williams said, to quote, fix this mess? Don't we have a whole lot of least worst options here? Is the commission not faced with a whole lot of least worst, and we have to pick from a lot of options, the least worst option? Would you characterize it as that?
It is a very difficult situation, and I would not disagree with that characterization. It's a difficult spot.
So, in picking the least worst option and restoring the public trust, you're talking about the alternative plan that's been offered. And I think, as Commissioner Elam just alluded to, it's only about 1% difference in the in where we are now. If that were to go forward, and I think it's been entered into this case, several plans. One of the plans included the $1,000 relief up front to the average ratepayer, and that's been debated a lot too. And of course, the biggest discussion has been the long-term, many years out, going forward ratepayer relief. What do you think balances the long-term ratepayer relief and then this offer of the $1,000, which has been advertised over and over to the public, and then the public not get quite what they think they're going to get, or not get good enough long-term relief? What do you think would be best to restore public trust and be best in the eyes of the ratepayer based on what's been offered and what's been told to them?
Well, that's a very difficult question.
Well, that's what we're looking at, and I'd like to hear your answer.
I understand, and I will provide that. I think just my personal opinion, no research behind this, but there's a temporary rate in place today, and as one of the interveners asked me yesterday, I believe it was Mr. Richardson, that if Dominion's Plan A is adopted, the customer will feel like there's a rate increase, even though we understand technically it was a temporary reduction. I think there appears to be some political support for the Plan B because it is close to the temporary rate reduction that's in place today. I think one of the most important considerations to me is to be able to take this very difficult situation, or mess, however we want to call it, and get this thing behind the state, the customers, the company, the employees, and be able to focus going forward. And a critical part of that is having a financially stable utility. And Dominion Plan A or Plan B provide that. And I would agree with, I think it was Mr. Cullen that said it's really a public policy decision as to which of those are. But it seems to me that the rate reduction is appreciated. I also understand people like cash in their pocket, and people enjoy that at a tax refund time in the spring of the year. So I think that's probably depends on the individual customer, and I just don't have any research around that to know which is preferable.
So you say certainty is the thing that not only the company but the markets are looking at, and certainty would be a good thing for the ratepayers.
Yes, sir. And what I meant by that, I don't know that I fully responded to that part of your question. What I think would be a terrible situation is 2 years from now our cost of capital to be 10 or 20% higher than it is today because of the incredible financial constraints if we were a standalone company and tried to implement the effect of one of the Dominion plans. So I think somebody's not going to be happy with Plan A or Plan B. I believe that's inevitable. But what we hopefully don't compound it with is frustrated additional costs down the road because of a increased cost of capital to invest this $500 million a year in the system of SC&G.
And speaking of that, speaking of the being a standalone company, in your opinion, what is the opinion of the employees? Not only the ones we mentioned, the senior staff that you mentioned, Ms. Griffin, Mr. Kassam, and some of those folks, but what is are all the employees of the company in agreement that this merger would be best for everyone involved at the company, or are there some folks who think at the company now who think SCE&G ought to try to stand alone?
I believe that there's very broad support for the Dominion merger. I also acknowledge that not everyone would be happy with that, but I believe it is a minority of the employees.
You don't have any kind of, when you say minority, you couldn't offer up any kind of number? Are you talking about employees in general, senior management? Could you offer any further?
I'm responding to the broad employee base. Certainly there's more risk at the senior management level, I think, of job security. But I think the broad employee base they're like the customers. They're ready for an answer and ready for stability.
Let me ask you a couple more things and we'll wrap up here. Are you able to discuss the idea that's been pushed forward about securitization by some of the interveners?
I've got a high-level knowledge of it.
Well, I'm going to try to ask you a few questions. Hopefully you can answer about securitization. How would securitizing the company's NND cost affect the company's title to the abandoned NND assets, to the two units, the two abandoned units? In other words, if title to those units is transferred to a special purpose entity, a special purpose vehicle, whatever you want to call it, would it be possible for the company to reacquire those abandoned assets in the future? And I know you've sought the federal tax credits and you're not going in that direction now, but in your mind, would it be possible?
Yes, sir. Ms. Griffin can correct me later if this is not correct, but I don't believe the title of any hard assets would move into this special purpose entity. I think it is just the access to the cash flow streams from anything that would be part of securitization legislation.
I realize title to other assets wouldn't, but even the abandoned assets, you don't think title?
I don't believe so.
So if no title, if that didn't occur, either with securitization, let's just say that didn't occur, or securitization didn't, we didn't even go down that path because we don't have legislation in our state for that currently anyway. Right. In your opinion, how does the ownership, I realize you're still in partnership with Santee Cooper under Unit 1, still producing power, and you've cited that, but in your mind, who owns the assets going forward? You're basically walking away from them as hard as you can go to convince the IRS to give you the federal tax credits. Then what's to stop Santee Cooper, either as they are in their, and we don't have any authority over them, as you know, in their current state-owned public power role, or in the future if someone were to buy them out, to come in there and say, hey, it might be unfinished, but these two assets belong to us. How does that work in your mind? You're the CEO now, so I want to see what your understanding of that is.
Let me recap first for you. The kind of order of events that happened is the economic decision was to abandon the project. then the consideration was, what's the appropriate tax treatment? So that was the order. The tax treatment came after that. The tax treatment didn't drive the decision. And we are working, I believe, very cooperatively with our colleagues from Santee, some which are sitting behind me here, to try to effect transfer of title to them through the NRC and other arrangements so that they can make best use of those assets for their purposes prospectively.
I know for a while they kept that NRC license active. Santee did, and was doing some maintenance to the project, but I think that's been since let go. Is that correct?
I don't have a up-to-date status for you on that, but we are working to effect the transfer of the license to Santee.
As far as you know, they still hold that license.
Well, I think we still jointly hold it, if I'm correct about the status, but we are working to transfer that ownership all to Santee.
All right, Commissioner Whitfield, I'm going to interrupt you for a second. We're going to break. We'll be back at 1:10.